Hi, I'm Tom Marks with the Marks Law Firm in Orlando, Florida, and welcome back to the Healthy Family Law Attorney 2022. This will be my first video this year, and I wanted to follow up on my prior video where I answered the question for a viewer that asked, what do I do if I want to move out of the jurisdiction of Florida? So if you want to watch the first in the installment, just go back and watch that one. And that first video was on Florida statute, chapter 61.13001, subsection 3, which talked about the petition to relocate and basically 7 allegations or factors that you need to include in your petition. So check that out. Today, we're going to talk about the same statute, 61.13001, but subsection 7. And these are the factors that the court must take into consideration when analyzing the case and making a ruling on whether you're going to be allowed to relocate or whether the objecting parent is going to prevail and you won't be allowed to relocate. So there's 11 factors there. I'm going to hit the first 5 today and then the remaining 6 in the next video. So I won't make this too lengthy, but it's a very involved statute, and it's really the interplay or the conflict between the parent wanting to relocate and the objecting parent or other person. So let's dive in. Let's look at the first of the factors under the statute. And this is subsection 7, subsection A. And let's look at it. It says the nature, quality, extent of involvement and duration of the child's relationship with the parent or other person proposing to relocate with the child and with the non-relocating parent, other person, sibling, half siblings, and other significant persons in the child's life. Okay, first of all, so we know who the parents are. Who is this other person the statute is referring to? Well, it can be, the other person can be a legal guardian under the guardianship statute, or can be a temporary guardian under Chapter 751 by extended family member. So the court has to take those people into consideration also. So what this subsection A is talking about is really, what is the relationship between the parent wanting to relocate and the parent objecting? And this is really where it's going to be about. So what is the extent, the duration, how long has the child been in relationship with each of the parents? Most of the time, it's for the child's entire lifetime. Sometimes it might be in a paternity situation where, let's say, the father comes back into the life of the minor child, or it could be the mother in that event also. So the statute is also talking about the nature and the quality and the extent. So that means, has the objecting parent or the relocating parent delegated the child rearing responsibilities to third parties, like a grandparent, like neighbors, like good friends, or has each of the parents been intimately involved in the child's life? The court's going to get into that, and that's going to be an important factor for the court to consider and for each of the parties to allege to the court and to present testimony to the court. So the court is also going to look at what is the child's relationship with siblings, half siblings, and other significant people in the child's life. So that means really close friends at school, in the community, in the neighborhood. Are there other half siblings? So in a blended family, has the child or children established significant relationships with those children? It is possible to ask to relocate with one of the siblings. Typically, the courts don't favor that. I would not typically recommend that. I'd have to see some very unique circumstances why a brother might relocate without other brothers or sisters or vice versa. So subparagraph A is really looking about the extent of the relationship between the children and not only the parents, but also other significant people in the children's life. All right, let's look at subparagraph B. This is the second factor the court must consider in a relocation case. This says the age and developmental stage of the child, the needs of the child, and the likely impact the relocation will have on the child's physical, educational, and emotional development, taking into consideration any special needs of the child. So this is focusing on the child, and this is what Chapter 61 of the Florida statutes really does focus on, and that is what is in the best interest of the minor child. What's going to impact their emotional, their physical. It can really lead to spiritual, educational, psychological needs of the minor child. So there's a lot that's going to be put into that. There's going to be a lot of witnesses that can be brought to bear in court regarding that. School teachers, Sunday school teachers, medical personnel, pediatrician, nurses, others, especially if the child is a special needs child. The court's going to take into consideration that in a very unique and special way and look at all medical, psychiatric, psychological needs of that minor child. And especially nowadays with children dealing with all kinds of special needs and all kinds of depression and psychological issues, the court's going to have to deal with that. And there's going to be a need for medical testimony in that regard. All right, let's check out now subparagraph C, the third factor in this statute. It says the feasibility of preserving the relationship between the non-relocating parent or the other person and the child through substitute arrangements that take into consideration the logistics of contact, access, and time sharing, as well as the financial circumstances of the parties, whether those factors are sufficient to foster a continuing meaningful relationship between the child and the non-relocating parent or person, and the likelihood of compliance. So this gets really deep into it. So what are these substitute types of time sharing or contact or communication between the non-relocating parent and the child or children? So obviously that would be virtual contact. That can be FaceTime, any type of numerous apps that allow that type of time sharing to occur. What type of transportation requirements will also be included, like how frequently the minor children visit or spend time with the non-relocating parent. I've seen situations where the minor child has actually had to fly between Orlando and Nashville every other weekend. So the child was half the time almost in Orlando and half the time almost in Nashville. Very difficult, very hard on the child. It prevents a child from having a lot of time to be involved in extracurricular activities, sporting events, and so forth, if the child's not in one geographical location enough to really get involved in those activities. So where it talks about the likelihood of compliance, that means, okay, so is the relocating parent going to actually comply with and pay for these time sharing arrangements, alternate time sharing, whether it be physically, airfare, whatever other types of transportation, or virtual communication? And flip side also, is the relocating parent going to really give the non-relocating parent that type of access, virtually or otherwise, on that what is ordered by the court? So the court's going to look at past disputes between the parties, past compliance or non-compliance by the relocating parent probably more so than the non-relocating parent or other person. All right, let's look now at subfactor D. And this is the preference of the child based on their age and maturity. This is similar to Chapter 61.13, subparagraph I, that talks about the reasonable preference of the minor child based on their intelligence and maturity and experience in just a time-sharing dispute. And I did a prior 5-part series on the 20 factors the court has to take into consideration in a time-sharing case, parenting plan, and so forth. This is very similar here. It just says age and maturity. So it doesn't say what the age is. A lot of my clients and others will ask me, so at what age can the minor child decide whether they want to live with one parent or the other, or if they want to relocate with one parent or the other? And really, the court's going to do what's in the best interest of the minor child. The court will typically consider the reasonable preference of the minor child based on maturity and age, but will do really what all the other factors considered will tell the court is in the best interest of the minor child. Well, certainly if the minor child is 15, 16, 17, approaching majority age, the court will give greater weight to that. Maturity, though, also says that some 15-year-olds are more mature than some 17-and-a-half-year-olds. So the court's going to look at those factors, and we'll look at intelligence and experience and other factors like in the other statute, 6113. So finally, for this video, subfactor E gives us more to look at. Let's check that out. Whether the relocation will enhance the general quality of life for both parent or other person seeking the relocation and the child, including but not limited to the financial or emotional benefits or educational opportunities. So enhance the general quality of life. So let's look at that. What does that mean? So I think it's really important to compare and contrast here. If the parent and the minor child are living in an apartment, maybe not in a great area, but they have the opportunity to live in a more affordable community where they can have a house and a yard and maybe a dog or cat. So the court's going to look at, are there going to be additional or better or improved educational opportunities, cultural opportunities, parks, extended family, better schools, just all kinds of improvements from where the child or children are currently living. It's going to be the objecting parent's obligation in these proceedings to show the court it's maybe not going to be as good, certainly not better than where the child or children are currently living. So the objecting parent is going to be giving the alternative view to the court of how good or how much better it would be for the minor child or children to stay in the current situation. There may be extended family members here, siblings, half-siblings, others that may be very important for the court to consider. So this is really going to be a tug of war, and it's really hard. This is not a situation where the court can just cut the baby in two. You know, the wisdom of Solomon. These are some of the most difficult cases the court has to consider. And it's really going to be going with one parent or not. And the parent who's relocating has to really consider, are they going to relocate if the court doesn't allow the child or children to go with the relocating parent? All right, so that's 61.13001, subsection 7, subsections A through E. We'll hit the remaining subsections F through K in the next video. I hope this has been helpful. It's my purpose to provide hope and help to families to successfully navigate the family law process in a healthy way. I hope you've done that. Please hit that like and subscribe button, the bell icon, and I'll see you in the next video.